Proceed. Credit. Receive credit for attending. You need to watch webcast. Alright. Send email the presenter. Following information. And the four codes given the duration of the webcast, 2 per hour. Two per hour. Deterrence. Deterrence. Starting. You will need, will also need by email later. Oh, wait. So please download PDF. Also, please email me at the program at with your name during the webcast 2 4 each hour. You can get to get live credit. See you. We'll be back. Back shortly. Be back shortly. Testing. Testing audio levels.
Testing, testing. Testing audio levels. Testing audio levels. Testing, testing. Testing audio levels. Testing audio levels.
How are you doing? Pretty good. I'll deal with it today. Perfect. Have a good New Year. You too.
Okay, just going to confirm real quick this is on. It keeps saying off the air in my end, but I think that's a typo. So for those of you who are watching right now, though, we'll be starting just a moment. Just wanting to make sure this is actually working right. It's the first time I've used this system in a while. So be just one moment before we begin the program. Okay, I'm checking on another computer. I'm just checking to see if it actually is feeding live like it's supposed to. Testing audio levels. Testing. Okay, I'm checking on another computer. I'm just checking to see if it actually is feeding live. Perfect. Okay. Looks like we are good to go. Well, for those of you who are watching live, I want to thank you so much for tuning in. And just a reminder, in Oklahoma at least, and other states in which the rules are, you will get credit for live webcast viewing as compared to on-demand viewing. So kind of a big plus there. Anyway, though, I want to introduce myself and kind of give a couple of real quick housekeeping stuff before we get started in the program itself. My name is James Branum. I'm a civilian attorney. I've been practicing for about 11 years now, mostly in the area of military law. I've represented a good number of military members of active duty and reserve members of the U.S. military, particularly from the U.S. Army, who are dealing with issues of conscience, but who are also wanting to be discharged for a variety of reasons. And I help them to navigate the system to find the best way out. I also defend some who are entangled in the criminal justice system, which is the topic for today's presentation. So, also want to mention real quick about our sponsors. This program today is being brought to you by two groups, the Center for Conscience and Action, which is the group I work with here in Oklahoma. We're an organization that works on a variety of human rights issues, including military law issues. We're also co-sponsored today by the Military Law Task Force of the National Lawyers Guild. This is an organization of military law practitioners, including attorneys, legal workers, and others who are engaged on military law issues. Find out more about them at their website, nlgmltf.org. Anyway, though, let me just go real quick. Housekeeping issues. If you have not already done so, you should download a copy of the manual for Courts Marshal. We'll be using that today. So 2016 edition is the newest version that's compiled all together. You can find that if you go to the website for the CLE, centerforconscience.org/CLE. There will be a download link there where you can download the whole thing as a PDF. So we're going to be referring to that often in the program during both hours, so you want to have that ready. Also, if you're wanting to have a chance to get CLE credit for this presentation, I need you at the end of the program, you'll need to email me. My email address is girightslawyer@gmail.com, and that is again girightslawyer@gmail.com. And email me with your name, your state, your bar number, and then there will be total four codes given during this program. 2 for the first hour, 2 for the second hour. So when you hear those codes, please write them down. The bar requires this as proof that you attended the presentation. If you send those to me, I'll have proof that you did attend, particularly for the live webcast. It's especially important we show that you're watching it live. We'll have different codes for the on-demand broadcast. But if you watch it live, you get credit for that, depending on your state's rules. So send those to me. If you're in Oklahoma, we have a pending application for CLE credits. You hopefully, no hiccups involved. You'll be getting credit for that and before the end of the year, so you'll be good there. If you're from another state, what we will do is send you a certificate along with a uniform application for accreditation of CLE activity, which most states will honor. You may have to pay a nominal fee for that, but other than that, it's usually a pretty easy process. And so anyway, it's up to you, though, if you want to do that or not. So anyway, housekeeping out of the way, let's go ahead and get started in the presentation. I'm going to take off the jacket. A little bit hot in here today. So for this first hour, we're going to be discussing, comparing and contrasting the military and civilian systems of military justice. And part of the rationale for why I'm wanting to do this is that I believe that a lot of civilian attorneys out there, one, would like to know more about this system, but also are quite intimidated by it. what little many of us know is from TV, from old reruns of JAG or something, but very little practical experience. And so this leads to some negative outcomes. One is that a lot of really good practitioners who would be great attorneys defending military service members who are needing outside assistance sometimes don't get that help because they are intimidated, they're nervous, and they think it's much more complicated than it actually is. On the other hand, there's also attorneys who go into this too blithely, too flippantly, not understanding some of the key differences in the system. And not just the differences procedurally, but more importantly, or well, equally important, the cultural differences. And so today I want to give a little bit of an introduction to some of those differences because I believe that having this knowledge is power. I also, though, my hope with this program is also to hopefully persuade some people to step into this area of law. I think it's an important one. It's one that we need more people doing. So, and finally, one last thing I'll mention is that there are lessons to be learned. Many attorneys, we care about the system. And so many of us are involved in various forms of advocacy to make the system better. And there are things that we can learn from the military system of justice that will be very helpful in the things we learn in the military system that will be helpful in the civilian system and vice versa. There are things the military does better than the civilian world, and there are things the civilian world does better. So I'll talk about them, particularly some very specific procedural things that could be a great improvement. And so whether you ever intend on doing military law yourself, knowing about these differences and how they work can be useful in other arenas. So, okay, so if we now delving into the nuts and bolts of what's different and what's the same about the military system of justice versus the civilian system of justice. Well, you have to begin with the philosophical side of things. At the very base, at the most important level, what is the goals of these two systems? How do these systems, what are they trying to achieve? Well, in the civilian system, and again, this isn't always stated in statute, but in theory and discussions, you often hear the ideas of retribution, of deterrence, of rehabilitation, and of course of justice and fairness. That these are things that the system wants to be not convict the wrong people, it wants to convict the right people who have committed acts, and then by having that conviction, then those goals and punishment of retribution, deterrence, rehabilitation can be brought about. The military system of justice is similar in that it has many of those same goals, but with one little, and well, I should say huge wrinkle, and that is the idea of military discipline. The idea is that for a military to effectively function, to do its work, and whether you agree with the work or not, the system is built upon the idea that the work must be done. Then it requires discipline. And so that affects the issues of deterrence. In other words, often soldiers, service members of various kinds are punished not for so much of the effect upon them, but as a deterrence to other service members who might be contemplating the same action. So that's a very different wrinkle. And because of that wrinkle, the courts have granted the military authorities some extra latitude in some ways in bending the rules when it comes to the Constitution and whatnot in some key ways because of this issue of military discipline. So that's a key issue. We'll talk more about how this plays out later, but that is a very different goal. In other words, the civilian system at the end of the day isn't really concerned about whether we're making good employees out of people who get entangled in the system. They're not concerned with this broader mission that's related to the institution. It's much more general and vague in nature. In the military, it's very specifically focused on military efficiency and discipline. So, another key difference in the systems is the issue of who are the players, who are the participants in these systems. And so I want to talk about these a little bit. We'll begin, though, by comparing, and I'm going to focus today on the state criminal defense system, and for a couple of reasons. One is that more of you are familiar with that. Also, I am more familiar with that. I have not done federal criminal defense law. I've only done it on the state side, and of course military law, which is part of the federal system, but I haven't done federal civilian criminal defense law. So I'm not going to talk about something that I don't know a whole lot about other than just in my own study. So instead I will talk, though, I will compare the two systems from the standpoint of looking at how the state system compares with the military system. So in a state criminal proceeding, who are the players? Well, you begin with the parties in the case, state of Oklahoma or state of wherever versus John Doe, the defendant. So you have a plaintiff and you have a defendant. And in this case, the plaintiff represents society as a whole through the prosecutorial system. On the state side, they are represented in Oklahoma by a district attorney. And of course, on the federal level, be a U.S. attorney. In Oklahoma, though, very few of us ever deal directly on the defense side with the DA. We mostly deal with ADAs, assistant district attorneys. These are the people that day in, day out make many of the decisions. They are the ones we go to court with that are sitting at the other table. The DA, again, is giving that general, broader direction, guidance. And in a smaller county, maybe making many of the calls. In a larger county, the ADAs have a great deal more power. So our day-to-day interaction is with the ADA, but the final call of whether a case is brought to trial and whatnot, whether it's moved forward, is done through the DA. Now, for the defense side of things, in the civilian system, there are two options. A defendant is either defended by a private attorney of their choosing, who they hire, who they normally pay money to, or if they're lucky, they get someone to do the case pro bono, but again, almost always pay money. And then the other option is for indigent people who've been found to be indigent through the system. They may be represented by a public defender. So those are the parties. The state versus the defendant. Each is represented by, on this side, by the district attorney or ADAs. On the other side, by a private attorney or a public defender. Now we also have the judges. In Oklahoma, interestingly enough, like many states, the district judges are elected, but then the other judges may or may not be, depending on what level they're at. The jury is a key component of cases that go to trial. The jury is going to be randomly selected, and then through a vetting process for the voir dire process. And at least theoretically, the jury pool should look something like the community where the defendant is from. And then finally, other players in the system are going to include, after a trial, and assuming there is a conviction, you're dealing then with issues of clemency, parole, and there's all the players involved with that. So this is the personnel. These are the people that the system deals with. And I should add here, and this is an important one, is paralegals. Paralegals are a key role, particularly on the defense side, for many attorneys and for many public defenders. And for many clients, those paralegals are people they may deal with as much or more than the actual attorneys. And so they're an important part of the process. And we'll talk about them more on the military side as well, because I think that they are a huge part of the process, military side of things. So that's the civilian system. And again, I'm comparing it with state criminal defense in Oklahoma. Every state's a little different, but the general skeleton is the same. Now, let's consider the military system and look at it compared to the civilian system. In the military system, the list of players is similar, but with some notable additions, some pretty big additions. First and foremost, in the military system, we deal with the command. Now, the command is referring to normally what's also called the convening authority. Normally, it's going to be the post commander for a major installation. It may be a smaller level of command depending on the situation. But the command in a military case has a great deal of power, much more power than would normally be present in really any person in the civilian sector. Because the command in the military system has the power to make a decision whether or not a case is prosecuted or not. And if not, what alternative means may be used to achieve the military's goals. For instance, will a soldier be kicked out with a bad discharge, given administrative discharge? Will they be given a Chapter 10 discharge in lieu of court-martial? Will they be mercifully let out on some other grounds? Will they be allowed to continue their military career? Will they be given a lesser form of punishment called Article 15? Punishment. These are all decisions that are made by the command. In some ways, you could compare this to the role of a DA in state context, where the DA is the one who makes the final decision, but the ADA is the one you deal with on a day-to-day basis. But it's a little different in that the are not only to decide whether to prosecute or not, whether to agree to an alternative situation, but also to make decisions about where this person is going to live of this trial, what's going to happen after this trial is done. Even though they're not guilty, even if there's not a conviction, the command can make decisions that can radically change someone's life for good or ill. And so the command has a great deal of power beyond just the case at hand. The command also actually convenes court-martials. Now, what this means is, in the civilian world, right now, I'm sitting here in downtown Oklahoma City. Graciously, my brother's office here, the Branum Law Firm, my brother John, has let me use his office as a nice place to do this recording. But a few blocks from here is the Oklahoma County Courthouse. Well, that courthouse was created, that court was created, I think at statehood probably, when the Oklahoma Constitution set up the district court system. And so that court is always in existence. It doesn't spring into existence and spring out of existence. It always exists. The military system is different. While there might be a physical courthouse in a particular military post, while there might be an assigned judge who's always available to take on cases, the court itself, in some theoretical sense, does not exist until it springs forth when it is convened into being, which is really weird when you think about it, but that's how it is. And so because of that, what that means in effective terms is that, again, a great deal of power rests with the command. Also, another power of the convening authority is to decide who's going to be on the jury, quite literally. Now, in the military context, we call this a court-martial panel, not a jury. But in any court-martial that moves forward and actually is going to be decided by a jury, and the defendant has the right to say yes or no on this, if the defendant says, I want a jury, or in this case, a panel, for an officer, it's going to be all officers on the panel. For an enlisted soldier, it will either be all officers or half officers and half enlisted. The problem is that sounds great that at least it's half enlisted, but here's the problem. Those enlisted are handpicked by the convening authority, and they will all be high-ranking enlisted personnel, NCOs, non-commissioned officers, sergeants and above. In other words, for the average defendant in the military justice system, there is no such thing as a jury of one's peers. There will be no one on the court-martial panel who is the same rank as the accused in most cases. And so there is a huge gulf, a huge gap in experience, and a huge gulf between the understandings and just life perspectives of these two groups. And so that's a real problem. But also what it means is, again, the command has tremendous power. If the command thinks that someone is going to be easy on someone, going to be lenient, well, that person will not be generally picked to be on a court-martial panel. That's a real problem. Also, in the context of plea negotiations, who makes the final call? What happens? What's accepted and what's not? Well, it's not the prosecutor. We'll talk about their role in a second. It's important, but they make recommendations, but the final decision is not made by the prosecutor. The final decision is made by, guess who? The command. This, in my opinion, is a real problem. Now, there are issues that in the military, there is the issue of what's called unlawful command influence, when a command tries to influence the system in inappropriate ways. But in most cases, the command never has to do this, and this motion never comes up because the system is already designed to give the command a great deal of influence on what happens. In other words, this is designed to elicit, when a command decides to prosecute, it's designed to get a conviction, in my opinion. So these are big negatives, the role of the command. You can't get away from this. Now, the justifications for this in the military context is that the military needs discipline. And military discipline hinges upon the system having this great deferential respect to the command. The command is focused on not the role of the individual, but the mission and the collective whole, and therefore a great deal of power is given to the command. Certainly from a military efficiency standpoint, that makes sense. From a justice and humanity perspective, not so much. Okay, we talked about the command, and we'll talk more about the command both in this presentation and the next second hour. But let's talk about some of the other players. The role of prosecutors we should talk about here. They're a little different, but there's also some similarities. with the civilian system. First of all, though, is terminology is a little bit confusing. Depending on which branch of the military you're dealing with, we'll use different terms. For instance, most of my experience has been with the Army, and in the Army side of things, they call them normally trial counsel, or sometimes just SJA, staff judge advocate. But normally trial counsel is what you normally hear. You hear different terms in different branches on for both the prosecutor and the defense side. But my experience is mostly Army, so that's what we'll talk about. Now, the trial counsel or the staff judge advocate, they wear several hats. One of the hats they wear is that of being the command's legal advisor. So the prosecutor is not only the prosecutor of criminal offenses, but also advises the command on every step of what they do. So if a command is thinking about doing X, Y, or Z, who do they talk to find out if it's legal or not? They talk to their JAG. They talk to their trial counsel. And so these people have an intimate connection with the command, and depending on what level of the command the JAG is dealing with, they may meet with them very often. They may meet with them just once a week or even once a month. It just depends on the individual post and caseload and everything else. But at the end of the day, these decisions are made by the command. The prosecution simply is there to advise and say this is legal, this isn't legal, but the actual decision of what happens in most cases still rests with the command. Now, that's not to say the prosecutors do not have power. The prosecutors are the ones who do the initial, once the command effectively has referred a case over, sent it to make a decision whether prosecution will happen, one of the steps will be the prosecutor looking at this and saying, yay, nay, this is a good idea or not. At that point, then, they are going to talk with the command. Decision is going to be made. And then once the ball is rolling, the initial charges have begun. In the military, there's a referral and referral system. It's a little bit muddy and complicated. We can talk about that's really out of the scope of this presentation of how that exactly works. But generally, what I'll say is for the role of the prosecutor is that they're the ones dealing face-to-face with the defense counsel. At the same time, quite often the answer when discussing particular possibilities will be, I have to go back and talk to the command, or I think I can sell the command on this, or I don't think the command's going to go for this, but we can try. You hear that a lot. In other words, throughout this system, the prosecutor is more go-between than anything else. But at the same time, the prosecutor will also be the one that when this case goes to trial, who will be arguing it? It will be the prosecutor. It will be their tactical decisions that are at play. And so these folks are really important. Now, what can I say about these prosecutors? Well, first of all, I can say that they are very well trained. These are all law school graduates, of course. But then after that, they go to a special JAG school, and they do extensive continuing training throughout their military career. They also, after most trials, they have a session called the Bridging the Gap session. And during this, the military judge will sit down with the prosecutor and the defense counsel. And if you're lucky as a civilian practitioner, sometimes you'll get to sit on these too with the military defense counsel. You get to hear basically the judge critique the case after the fact. And the judge usually will not go into the deliberations of how he or she decided this or that, but will instead critique both sides on how they practiced, how that they explain things. And this is a very, very awesome tool to get to learn from. And so because of that, again, military attorneys, I think, are very well trained. And having this ongoing experiential training from the judges themselves is very useful. Okay, so we've talked about the role of the command in the military context. We've talked about the role of the prosecution. Let's now talk about the defense side of things and compare that with the civilian system. Well, in the defense system, what is very unique and I think really cool is that the right to counsel, with one exception we'll talk about later, but one major exception is very, very awesome and very helpful to the defendant. The most notable being that unlike the civilian system, a defendant in the military system has the right to a government paid for attorney, whether they are indigent or not. They do not have to prove they're indigent. They get one. They can fire that person. They don't have to use military counsel, but they have someone paid for, and they don't have to prove they're indigent to get this. And so because of that, almost every defendant will be represented by counsel provided by the government. For the Army, they are called TDS, Trial Defense Services. For the Air Force, they're called ADC, Area Defense Counsel. The other branches, I don't know because I haven't dealt with them in a trial on code of law. But on the Army side, TDS is who I mostly deal with. These folks are very experienced. In fact, my understanding is that they normally, most TDS, maybe all TDS attorneys, begin on the prosecution side, and later, if they work out well there, they get moved over to the defense side. They are also under a different chain of command than the prosecution JAG. So when you become a defense attorney, you switch chains of command, which helps to avoid some of the legal ethics issues. They also, from what I can tell, are scrupulously, both sides, careful to follow the rules and to keep their clients' interest at stake, meaning that they will be friendly and civil with each other, but you're not going to see any inappropriate sharing, anything like that. And it's just like in the civilian world that people may be civil, they may be nice, but there's a limit to how friendly you can be, given the confidences each side has. And in the military system, what I've seen is they are very scrupulously rule followers when it comes to that. So the positives of the TDS attorneys is they're very experienced, they know their stuff, and they know military culture. They are part of the military, just like the prosecution side are. Now, some defense and prosecution attorneys in the military were prior enlisted. Maybe they served before law school, maybe they were in the reserves during law school, and later became officers and became attorneys. Others went straight from law school to officer training and then their final JAG training and then becoming lawyers. My experience has been that those attorneys who were prior enlisted first have a lot more experience. Sometimes those who have been officers the whole time, they may not relate as well to the experiences of enlisted personnel. So that's a bit of a negative. Also, I'll say that my experience has been that the trial defense services, the government provided legal attorneys, legal side of things, they can be overly cautious, in my opinion. For instance, they are not ever going to use press outreach in any way, which in civilian cases sometimes is a useful tool in various ways, particularly though in the military context. I think it's essential at times because the military, despite its protestations not to be, is a fundamentally political institution, which is ran at the top level by a commander-in-chief who is elected through a political process. Hence, public pressure can sometimes change the outcome in a case, particularly in the military world. Unfortunately, TDS attorneys, with very few rare exceptions, will not talk to the press, even if it, in my opinion, will be helpful to their clients. And so that's why often it is helpful for there to be an outside attorney, and that's where civilian defense counsel, CDCs, come into play. And I'm one of those people. And other civilian attorneys who step into the system, when they do that, they become CDCs. Now, the role, and what's nice, I love in the military system, is that the client doesn't have to pick which either or. They can go with both, meaning they can have retained, they have their own private attorney who's retained, but they also get to keep their TDS or ADC or whatever, which branch of the military they're in, their defense counsel through the government. And so what normally happens in practical terms is the civilian attorney sits first chair, the military defense attorney sits second chair. In different cases, there's been different working arrangements and how that all works. But my experience has been a very, very good relationship getting to do that. As a civilian attorney, what I really appreciate about working with these military defense attorneys is they know military culture in and out. While I've worked as an attorney with military cases for 11 years, I haven't lived the military life ever. I'm not a veteran. I haven't served in that kind of way. So I don't catch a lot of the nuances of military culture that people in the military will. And so I find that to be very useful. Also, it's just nice having another attorney, particularly a solo practitioner, to have another attorney to bounce ideas off of, to really engage with. So I find it to be a really useful situation. Also, it's extremely useful when you're dealing with issues of distance. Military posts are scattered all across the country and all across the world. And so many people civilians who practice military law, end up having to travel a lot. And so it's very helpful to be able to have someone local often to do some of the legwork and to meet with clients and to have them come to the office as a TDS office and meet with them. And often for me, the civilian lawyer, to be on conference call with them and the client. So I find it to be a really neat system. And so there's a lot of gripes at the military system. This isn't one of them. I think right to counsel generally is very, very good. With, again, one exception, the good old summary court martials we'll talk about later on. But generally, very, very good. Also, while I'm talking about the prosecution and defense attorneys, I shouldn't mention the role of military paralegals. Military paralegals are trained. These are usually enlisted personnel who have gone through the MOS, military occupational specialty, which you call your job with the military. Whatever your job is, they've gone to MOS school for paralegal school, and so these are folks who know how to get things done. And so oftentimes I end up working a fair bit with these folks on cases. And while I may have, the TDS lawyer, particularly some of the branch of the Air Force, those poor folks, they have to cover off in multiple military bases. There's not near as many as cases pending. So you may have someone who's traveling between, say, 4 or 5 different states. So who runs the place in the interim? It's those paralegals. They're the ones who are available day in and day out. And so those are really good folks. The one that practice tip I give for anyone watching this is be nice to the paralegals. These are folks who can help you. These are folks who, if you don't treat them well, they may not have the motivation. They need to do, basically treat them well. Be nice to them because they have a hard job, and it will yield good results. But it's also just a nice thing to do. Okay, so now dealing with more of the players in the military system, let's talk about the military judges. Now, unlike the convening of the court in this general sense, we talked about earlier, the command convenes it into existence. The judges themselves are part of their own chain of command. They're called MJs, military judges. These folks are very experienced, in my opinion, usually fair. They will normally be fairly high-ranking, normally at least lieutenant colonel or higher, and they will have most likely been previously a JAG attorney of some kind. So they've been on the practice side as well. I don't always like how they rule, like all of us do when it comes to judges, but as far as fairness, as far as knowledge of the law, these folks are really on top of it. They are usually older. And so, particularly in dealing with a judge-alone trial, I do try to bear in mind the generational gulf sometimes between service members themselves and the judges they're dealing with, because that gulf can be a big factor. So, by the way, this is a good time to do the first of our codes. Remember, we talked about at the beginning, if you want CLE credit, you need to write down these codes. It'll be 2 per hour. So the first code is B as in Bravo, 5, V as in Victor, L as in Lima. Okay, let me repeat that. Again, I'll give you a minute here to get a pen or pencil if you don't have one already. The code for this first code is B as in Bravo, 5, V as in Victor, L as in Lima. So at the end of this program, we talked about earlier, you'll need to send us an email to girightslawyer@gmail.com. That'll be on, by the way, the CLE page if you're on the website, or if you're looking at the chat thing on the Google Hangouts we're using for this video stream, you'll find the email address as well. But email me with your name, your state, your bar number, and these codes. And basically send me the codes for the parts you listened to. If you didn't watch the whole thing, you'll get credit for what you did watch. But there'll be 2 per hour. So the first code is B as in Bravo, 5, V as in Victor, L as in Lima. Okay, so that was code number 1, B5VL. Okay, so let's continue onward. So far, we've talked about in comparing the players of these two systems. We've talked about the parties. We've talked about the attorneys. We talked about the judge. Let's finally talk about 2 other levels of this. First of all, the court-martial panels themselves. Now, the military context, this is what we call another word for a jury. And as we talked about earlier, this is picked from a list that's provided by the command, a list of people. It'll be a list of officers and a list of enlisted personnel. If the defendant is officers, the whole pool will be picked from the officers. If it's enlisted, they have the option of saying all officers or half officers, half enlisted. By the way, I should tell you, conventional wisdom for enlisted personnel is that it's usually better to ask for all officers, because those high-ranking enlisted, because again, you're not getting juries of your peers. If you're low ranking, you're getting high. If you do ask for half enlisted, they will be high-ranking enlisted. And I need to turn that off. Okay. Sorry about that, folks. Normally, if an in-person presentation, I would say something about turning off your cell phones, but I forgot to do that myself. So it's turned off now. Okay. So continuing onward. Anyway, the conventional wisdom is it's usually best to ask for all officers, but whether that's true or not, I don't know. I've had one go to a panel. In that case, the defendant decided to go with all officers. But generally, I will say cases that go to a jury trial in the military are fairly rare for some reasons we'll talk about later on. But for those that do, the problem is it is not a jury of one's peers. It's going to be all high-ranking people handpicked by the command who made the decision to prosecute the defendant in the first place. So not a good situation at all. Finally, after a trial has happened, and after presumably in this case a conviction has happened, now the defendant has a chance to ask for clemency and to go through the parole process. On the clemency side of things, what happens is post-trial, the defendant has the right to present other matters in writing or in other forms that they want, that writing is what they're guaranteed to be heard on, to the convening authority. And the convening authority then, after the decision of the judge is made, it gets sent up to the convening authority, usually be several months down the road. At that point, the defendant then makes their request for clemency to the convening authority. The convening authority then looks over, at least is supposed to look over the record of trial and look at that request for clemency, and then we'll make a decision whether the original sentence will be continued or whether clemency in some way will be granted. So positive is, in some extraordinary cases, things can change. An injustice that happens at trial can be fixed. Bad news is it's the same person making the decision throughout the way, the command. The decision of who to prosecute is made by the command. The decision of whether a trial moves forward belongs to the command. What kind of plea negotiations, if any, are accepted, decided by the command. And finally, whether clemency will be granted and how, made by the command. The only intervention in this really is the prosecution's ability to, as the prosecution and the defense, their arguments back and forth as persuasion pre-trial to stop a trial going forward. And then, of course, there's the role of the judge. You can't have and or the jury pool. In this case, the court-martial panel. Those are checks as well. In other words, the command can't give someone a conviction and a dishonorable discharge if they haven't gone through this process of being convicted by a military judge and or the court-martial panel. But other than that, every other step of the way, who has control of it? It is the command. And that's a really important point. And I think it's something that we can't underestimate. The command has power through this whole process. So anyway, so for just a moment, let's give a little critical look at, we've talked, looking at the players in these two systems. What would we say positively and negative about each? Well, the big positive in the civilian system is that the various players have much more independent power, which means the prosecutor has the ability to make decisions without necessarily going all the way up to someone like a command in the civilian context. There's a lot more independence by the person who actually is trying the case to make a decision. While in the military context, the command makes a decision. And at the end of the day, what the prosecutor thinks is simply a recommendation to the command. It's not the actual. And so I think that's a shortfall of the military system is that so much power, and that power could be wielded unfairly. I also think that the role of the jury is far superior in the civilian system, where you have the jury panel is truly picked randomly through, and then a vetting process through voir dire. In the military system, I forgot to mention too, voir dire is much more locked down in the military system than it is in the civilian system. All of the judges, when asked of a potential jury panel, have to be approved by the judge in advance. This does not allow the kind of open-ended questioning that you're allowed in the civilian context. You're much more restricted on what you can ask for. And even if you got a particular court-martial panel member knocked off, it may not be that helpful to you because, again, every member of the jury panel has been handpicked by the convening authority. That's a shortfall of the system. Now, positives of the military system is the defense right to counsel, the fact that everybody gets a good attorney. And I should also add, let's say that you can't afford a private attorney. You get assigned a military-appointed attorney that you don't like, doesn't click, you just don't think is doing good for you. you have the right to fire that person and ask for another attorney if they're reasonably available in the military system that the government will pay for. That's extraordinary. I can't imagine the civilian system, if someone had a bad relationship with a particular public defender, that they could ask for a different public defender and actually have that request be honored. It's very unlikely. In the military system, that's embedded in the rules. And of course, then you also have the right to hire a civilian attorney as well at your own expense, and to have that attorney sit with and work alongside the military provided attorney. It's such an awesome, awesome benefit, in my opinion. And finally, the fact that in the military context, defendants get their attorneys, get their government provided attorneys paid for whether they are indigent or not, or whether they can prove they're indigent. You know, anyone who's dealt with the system knows there's a lot of poor people in the system who may not be able to fit under the bar for the government would deem to be indigent, but maybe desperately poor. And their family goes through tremendous financial, in fact, you know, the normal scenario is the family goes through tremendous financial hardship, just gets one bailed out in jail. They've blown through all their money for that, and now they're expected to get an attorney. And what do? They have a very limited choice of who they can pick because of finances. In the military, that's not the situation. Everybody at least gets their government-appointed attorney that's paid for by the government. It's a real positive benefit. By the way, we're getting a few more viewers on here. Excited to have everyone on here. If you have any questions along the way, I don't have it set up with the video and audio where we can talk. It gets a little bit muddy when I've done that before. But we do have a chat thing on the side of the page. And so if you want to have any questions for me along the way, I'll do my best to look at that occasionally and answer any questions you might have. So I do want this to be a two-way conversation to the best extent possible. So thus far, and kind of covering a little bit for those of you who are coming in later, thus far in this presentation, we've talked about the different goals of the military versus civilian systems. We've also talked about the various players in the military versus civilian systems, comparing and contrasting these two systems. So now I want to spend some time talking about the differences in procedural rules and practice. In other words, the nuts and bolts of how you do things in each system. How do you figure that out? How do you learn how to do those two things? In the civilian world, and again, we've been talking throughout this, comparing the Oklahoma criminal justice system. Other states will be similar in various ways. But in Oklahoma, what do we look at? Well, we're looking at the rules of criminal procedure. We're going to be looking at local rules. And of course, we're going to be looking at, along the way, sometimes case law, constitutional issues, and whatnot will also bear on procedural issues. But generally, we're looking at rules of criminal procedure, we're looking at the local rules, and then also lots of unspoken details that vary from location to location of which form you use for what. Who do you talk to when it comes to docketing and all that? Those all vary greatly from county to county. Also, in Oklahoma courts right now, and it's moving more in an electronic direction over time, but right now you still often have to meet in person for all kinds of things. Often something just as simple as a quick schedule change requires a meeting with both parties in person in a courtroom. The military system, thankfully, has made things much more efficient and much easier on that front. We'll talk about that more in a second. In the military system, procedurally, we're looking at two primary documents. We're looking at the UCMJ, the Uniform Code of Military Justice, and we're looking at the MCM, the Manual for Courts Martial. By the way, that was the 900-plus page document I mentioned you need to download if possible. And we'll be looking at that some throughout today's presentation, both the first and second hours. But the UCMJ primarily gives basically the laws of military, the criminal statutes, basically saying what the penalties are very, well, actually not giving the penalties. That's actually in the MCM. That's kind of an interesting thing. But the actual definitions of crimes is found in the UCMJ, which has the status of federal statute because it has been enacted by Congress, signed by the president, yada, yada. So the UCMJ provides the criminal statutes, but it also provides some, but very vague and not all of the procedural details of the criminal justice system. Much of the details are spelled out in the MCM, the Manual for Court Martial. The Manual for Court Martial has the status of federal regulations because they are enacted by the president through the president's power as commander-in-chief. That's the constitutional justification for it. What to me is interesting and kind of troubling, though, is that the MCM functions in many ways more like a federal statute. For instance, the penalties for various crimes, how much time a person does if they're convicted of X offense or Y offense. That's not defined by federal statute, the UCMJ. It's defined by the MCM, the Manual for Court Martial. Now, that to me seems just weird. The president gets to decide what the maximum lengths of sentences should be. To me, that seems very inappropriate. It's one of my critiques of the military system. But nonetheless, that's how it's structured. And up to this point, at least, the courts have allowed that to be. But the MCM also, besides giving the penalties for crimes, gives a lot of commentary on the UCMJ, explaining in more detail issues related to each of the offenses, and then also gives much more of the procedural details of what happens in a court-martial and what happens in various other contexts. There are also usually branch-specific regulations, or DOD regulations and branch-specific regulations on military justice that also fill in more of the details. Now, that's what the rules on paper. As far as how you actually get things done, what I like with the military system is these days, almost everything is done through email, which means many of the issues that you would have to go and travel to a county courthouse in the civilian system, if you're lucky, maybe get it hashed out on the phone with the prosecutor. But most often requires a in-person visit, possibly in front of a judge and all of that. In the military, often these issues are dealt with in email, and either conversations directly between prosecution and defense with various things, but also sometimes when it comes to docketing and whatnot, it's going to be a conversation between those parties and the judge. They're all on the CC together, so we're not having ex parte communication issues. This, to me, makes things so much simpler, particularly when it comes to plea negotiations, when you're trying to hammer out the exact details of what someone's pleading to. Military pleas are quite a bit more complicated in some ways than the civilian world. Usually there'll be a very, very detailed stipulation of facts. Well, the details of how that gets hashed out is not having to be done in person. It's done through email. And for me, I like that for many reasons. One, of course, is it eases the gap of distance between the practitioners that need to talk about these things. But secondly, and I think more significantly, is that it provides a paper trail. And I think for me as an attorney, it helps me to remember what is said. It's not just my own recollection or my own written notes, but I can actually look at the emails and say, oh yeah, the prosecutor said X, Y, and Z. It really is so useful. And I just like the efficiency of the system. It makes things go so much easier. And it's remarkable, really, how well this system works. And you have attorneys, one case I had that was at Fort Carson, Colorado. The judge was flying in from Alaska because she was previously sitting on trials up there. And she was on a circuit working all the way from Alaska. And the week before, all the parties and the judge are dealing with things by email. She's in Alaska. The prosecutor, I can't remember if he was in California at that point or if he was at Fort Carson, and I was in Oklahoma. We could hash out many of these details that needed to be dealt with, provide the appropriate notices and whatnot. It'd all be done by email, and it just goes so smooth, super smooth. So to me, that is one huge benefit of the military system, is a great deal more efficiency. Okay, lastly, I want to talk about, we don't have a whole lot of time left. I want to talk a little bit about how the laws of these two systems compare and contrast. What can we say about them? And again, I'm today mostly focusing on state criminal law. Federal is a little bit different, but on the state side of things, we think about what are the statutes, what are the basis of law we're dealing with. Of course, it's things written down and things in case law. I guess case law is written down too, but you know what I mean. On the first side, of course, is you're going to have at the very top of the food chain on this slide is the Constitution of the United States at that federal level. And of course, certain provisions, those provisions that do apply to the states, then that affects the state criminal system. Then next we have the state constitutions. And many states, including Oklahoma, have Bill of Rights, have other things like that in them, some basic protections given in the state constitutions. That will trump what's below that, which are the state statutes. And then sometimes there's also issues with state regulations. And then, of course, there are the rules of the various courts and whatnot. So it's you have a pecking order here. Those at the highest level will trump those below that, and so on. That is on the state side of things. and the civilian side of things. So we compare that now to the military system. It gets a little more complicated, but it's a very similar kind of concept. And to me, understanding this hierarchy is super, super, super critical. And without this, it's easy to get things really muddied. So at the top of the list for those in doing the military system, you have the U.S. Constitution, just like on the state side. Also, just like on the state side, there are certain provisions of the U.S. Constitution that do not apply to states. There's some of that only most things do, but not everything. And the same thing in the military side of things. There are some provisions, procedural protections in the military that do not apply to the military. I disagree with this decision, but it's in case law. The rationale is, as we talked about earlier, the issue of military discipline. Since the U.S. Constitution gives the president the power to be commander-in-chief for the military, the idea is that there is inherent in that an implied powers to maintain military discipline, which means that some of the constitutional provisions don't apply in military context, such as free speech. Free speech rights are dramatically limited for members of the military, not extinct, but in a way somewhat similar to federal civilian employees. For instance, they can't run for public office in most contexts as an active duty member of the military. They are limited if you're wanting to engage in a protest or demonstration as a member of the military. You can't do it while wearing a uniform, on a military post, in a foreign country, or in any way that there might be a chance it could result in violence. Great limitations on one's abilities of free speech. A whole lot of other things. But also we think about those procedural protections when it comes to a court-martial. What doesn't really apply to the military? Well, first of all, the right to a jury trial. As we discussed earlier, there is no jury of your peers in the military. It's a jury of people who are way up above you in rank, not really a jury of one's peers. Right to counsel in some ways is better than civilian world, unless you're in a summary court-martial. We'll talk about that in a second. There's an exception there as well. So there are some differences in these two systems. And at this point, it comes to the very highest level. There's provisions of the U.S. Constitution don't apply. Also, I should mention right to bail. There is no right to bail in the military. Instead of bail, there's the issue of whether you're put in pretrial confinement or not. But that's all there is. There is no bail as we know it here. Part of the argument, though, here is that a person in the military is always still in custody in some way. Even if you're living on post, you're still subject to the UCMJ if you're active duty. So bail, that's the argument made. But nonetheless, if the command decides they want to hold you before trial, they usually get away with it. There's a process you can contest if they basically most defendants are not put in jail, but those who are, it's called pretrial confinement. You can contest pretrial confinement, but very few people are successful in doing so. And again, the decision to grant pretrial confinement, it's a much lower bar than it is whether someone could be denied bail or not. But anyway, the top of the list, as we mentioned earlier, U.S. Constitution as defined by the courts through those military-specific exceptions. Below that are federal statutes. Now, the biggest federal statute we deal with in the military context is the UCMJ, Uniform Code of Military Justice. But there are other federal statutes as well, such as some of the equal employment statutes, such as conscience objector statutes, some of the whistleblower protections. There are things that are written in other federal laws that are also at this level. But anything that is a federal statute, in other words, that has been enacted by Congress, signed by the president, that is higher than everything else except the Constitution in this pecking order. Now, below federal statutes, and I should also add, it is a very small number of federal statutes. We're not talking about a huge number here. It's a fairly small compared to in the civilian context. Most of what we think of in the law of the military is at the next level, and that is federal regulations, except in this case, it is a multi-tiered system of regulations. All of these are federal regulations, but some of these are higher than others. And I would put these in three categories. At the top are DOD regulations, Department of Defense regulations that apply for the whole Department of Defense. I should add, one other complication is you have DOT, Department of Transportation, you deal with the Coast Guard. That's kind of a whole other category, so I'm not going to deal with it right now. But for the most part, we're dealing at this level at DOD regulations, which apply to the entire Defense Department, all branches. Now, DoD regs tend to be more vague, the idea being that the branch-specific regulations give more detail and allow some flexibility from branch to branch to do things a little differently. But the DoD regs do prevail over branch-specific reg, meaning that if a branch-specific reg contradicts the DoD reg should be followed. So that brings us next to branch-specific regs. And 90% or so of what you deal with in military law context has to do with branch-specific regulations. Those are the regulations that apply at the branch level. So, for instance, ARs is what we call them for the Army. Army regulations, such and such. Air Force has their regulations. Marines, the Navy, each branch has their own sets of regulations. I should add one positive is that most of these regulations are online. The negative is not all of them are. And it's often a big pain to track down the regulations that are not online, but most of them are. And usually, you just need to do a Google search for the regulation you're looking for. This type hierarchy of regulations are DoD regs, then branch-specific regs. Third level are post or command level regulations, instructions, etc. That's going to include one of the most common ones is most military posts will have an off-limits list. For instance, in most cities, there'll be a post for an Army town. There'll be a list of places that soldiers are forbidden from entering. It's usually places where there's been prostitution, drug use, other things like that. And so so that you're forbidden from going to those places. And if you go in those places anyway, then you're guilty of an offense under the UCMJ. There's other things like that. There may be regulations. Some posts have detailed regulations on motorcycles, saying if you drive a motorcycle on post, you're required to wear a special orange vest while on post, and you're required to go through a special motorcycle training. That's all at the post level. And so, again, in this hierarchy, DoD regs, then branch regs, then post regs. So each of these levels is a hierarchical system. So, again, comparing to the civilian context, you have a lot more layers and levels of complexity. So, anyway, so that's as far as what's written on paper. We now deal with case law. And case law in the civilian side is much more extensive. We have a whole wealth of appellate court decisions, recorded decisions at the state level and also the federal level, interpreting various levels of constitutional issues. We have, of course, persuasive authority and binding authority. In other words, binding authority is those decisions made by a court, either the court that we're dealing with or a court that's over that court. Persuasive authority is being a decision from another court that's not in the pecking order over here, but could be persuasive to this court over here. So we have tons of case law in the civilian context. Military context, not so much. Not near as many cases go up on appeal where there's actually a court decision. And so a lot more issues are unsettled. A whole lot more issues, which I think is exciting as a possibility as a defense attorney, but also frustrating because you don't always know how it's going to play out, which is very frustrating. To the extent that there are recorded decisions, you're not normally going to have much at the trial level, which would be the equivalent in the civilian world of, say, a district court on the state or federal level. What you will instead have are the Court of Appeals for the Court of Criminal Appeals. Each branch has their own appellate court, and then below that is the Court of Appeals for the Armed Forces. And I'm going to real quick pull up one thing. I did some notes here that's important. I don't have those handy. Anyway, that Court of Appeals for the Armed Forces as a whole, and then finally above that, you're going to have any time that you have either be kicked up to the U.S. Supreme Court or at any level, you also could have collateral attacks, habeas review in a civilian court. The challenge is that most civilian courts do not want to interfere in a military proceeding, hence they are very unlikely to accept these kind of cases. So there's much less case law out there, which can be challenging. Okay, we've covered a lot around here. I do want to open this up to questions. If anyone has questions, go ahead and type them on the chat screen that's on the page we're looking at here. But while I'm waiting for any questions, I just want to mention, to me, what I want to say as far as what we can learn from these two systems, what each system could learn from the other. I think the civilian system could learn a lot from the military system of saying that no one is served by having defendants without good counsel. I know a lot of people think, that feel like that we need to, in our desire to punish defendants, we need to not give anyone a free attorney for a defense case unless they really prove that they're desperately poor. But the military has decided that no, you really can't have a fair trial without an attorney. If someone can't afford an attorney or can't afford one that they feel comfortable with or that's good for them, they're not going to get a fair trial. And so they've said that everyone gets one, no matter what your indigency situation. And really the only choice is, do you want to accept that person or not? And I think there's a lot to be merited by that in the civilian system. And I realize it would make the system more costly in some ways, but in some ways, I think it might also make it more efficient. Imagine if the public defender offices in this state or other states were not just funded in the low way they are, but paid that funded quite well, so that every person in the system who wanted to be represented by a public defender could get a public defender and have someone who did not have a ridiculously high caseload, but had a more reasonable caseload, probably something equivalent to what the number of cases, say, the ADA, each individual ADA is dealing with. No more than that. What would that look like? Well, my theory is that it would mean a more efficient system. Continuances while someone is waiting to come up with the money to hire an outside lawyer. It would probably mean that more cases move forward in an expeditious way. And I think also by having people have good attorneys, no matter what it would mean is less wrongful convictions, which would mean for society as a whole bunch of benefits, to say nothing of just having a more fair, more just system. I think that's a huge benefit the civilian system could have by adopting something the military is doing. Now, on the military side of things, what could they adopt from the civilian system to be better? Well, the biggie would be to eliminate or greatly reduce the role of the command. The command has too much power in this system, in my opinion. The command should not be picking, for instance, the court-martial panels. That should be done through some kind of random process. The list of names of who's eligible to serve on these panels should be done through a random computerized process. They can do it. They have all kinds of computers. No reason they can't. Also, the jury panel should actually be a jury of one's peers, meaning that the jury panel, I think, ideally should represent the demographics of the military, but also should represent demographically the ranks of the military. I don't think officers should get to have should have the privilege of being elected judged by their peers, but privates don't. That's not fair. I would also say that I'd say that's the biggie. I mean, I think also, I would also add for the civilian system, they could learn from the military in that, boy, email sure makes things go smoother. And if more things could be done through electronic means, it would help a lot. So, okay. Real quick, we're about to end our first hour presentation. I need to give the second code. This is code number 2. So please write this down if you're wanting credit for this. The code is D as in Delta, 9, Z as in Zeta, and A is in Alpha. So code number 2 is D as in Delta, 9, Z as in Zulu, A as in Alpha. Just a reminder, these two code we gave earlier on this one, you need to email those to me at the end of the presentation if you want credit to girightslawyer@gmail.com. Send me your name, state, and bar number, and these codes. And again, if you want there'll be 2 codes for the first hour, 2 for the second hour. Just send the codes for the time blocks you want credit for. So we'll read it one more time, the second code. That is D as in Delta, 9, Z as in Zulu, A as in Alpha. Well, that finishes the first hour of the presentation. So we're going to take about a 10-minute break. When we come back, we'll get started with the second hour. So also, in the meantime, if you have any questions from the first hour you have, feel free to put them on the chat box. And then we'll add a message for those who are coming during the break. And we'll be back momentarily. We'll be starting again in just about 3 minutes. We'll be getting started in 1 more minute, but while we're doing that, for anyone new who's logged in for the second hour who didn't attend the first hour, I just wanted to mention that if you would like to be eligible to get CLE credit for this program, you'll need to send an email to me after the program is done to girights.lawyer@gmail.com. That address, by the way, is on the sidebar on the chat screen, but I'll read it out again. It is GIRIGHTSLAWYER@gmail.com. And you'll need to email me with your name, your state, and your bar number, as well as the random codes that we're given out during this webcast. We gave out 2 for the first hour, and there'll be 2 in the second hour. So when those come up, just be sure and write those down. And you email me with those afterwards with your name, state, bar number. Then we'll be sure and get things taken care of. Also, just mention, have it 1 more minute before we get started, that for Oklahoma, we have a pending application for accreditation of CLE activity. So we'll be sending in along with we're sending in whoever attended today from Oklahoma, we're sending those into the bar. As soon as we get the accreditation done, then you should get your CLE credit. For those from other states, What we will do is we'll send you your certificate of completion, but we'll also send you a uniform application for accreditation of CLE activity that you can submit with your state's bar. Most states will charge you a nominal fee for that, but I've submitted applications for quite a few different states that I've attended and haven't had any problems getting any of them accepted here in Oklahoma. So most states are pretty similar, I think. So anyway, we'll get that to you, and anything else we can do to help you with, if your bar wants more information or something to get the accreditation granted, just let us know. We'll do all we can. So, and also just mention too that we hope to be doing more CLE webcasts like this on a more regular basis. The groups I'm working with, the co-sponsored the event, the Center of Conscience and Action here in Oklahoma City, and then the National Lawyers Guild of the Military Law Task Force. Those groups, two groups, both want to do more CLEs like this. For the MLTF, be focusing on sports and military law issues. For CCA or group here in Oklahoma, we may also do more expansive and some other human rights issues as well. So anyway, though, it is time to get started for the second hour of this presentation. And for the second hour, our topic is defenses, mitigation, extenuation, and aggravation as it relates to absence offenses under the UCMJ. Now, that is a mouthful, I realize, and I tried to think of some way I could better explain this, but I really want to be very specific here because this is a really important topic. And this top presentation, you know, the first hour we just had was really focused on, was more general interest for people that may know very little about the military law, to compare and contrast the two systems and know what's similar, what's different. And we barely scratched the surface. There's a lot more we could have talked about. But for the second hour, we're going to be talking about this very specific issue that's related to one particular issue of military law representation. Now, I do want to make clear, though, I think a lot of the topics here about defenses, mitigation, extenuation, aggravation, the general concepts are important ones in many areas of criminal defense law, whether you're dealing with military cases or not. And so while the exact circumstances may be different, the procedure, how you do things, will be very similar. And I'm hoping that we'll give some methodology here that could be useful to you in your practice, whether you do military law or you don't. I also want to mention, though, that these offenses we're dealing with today are absence offenses. These are very different. There's nothing like this in the civilian world. If you don't show up for work in the civilian world, what happens? You get fired. You get written up. You get docked in pay. Or nothing happens. But in the military world, it's a big deal. Best case scenario is you get yelled at. More likely, you get written up. But also very likely, you may be facing criminal charges. Not showing up for work is a crime in the military. Normally, of course, short absences, not a big deal, or as a big a deal, but there's exceptions. I've known of people who have been prosecuted for being gone for a few hours. Literally, a few hours is enough to merit a prosecution in some cases. On the other hand, of the many thousands of people that leave the military post without permission in a given year, the overwhelming majority, are not prosecuted. So those who are unlucky enough to be prosecuted, they need to be aware of the circumstances of what they can do to most effectively get the best outcome. And so today we're dealing with the issues of defense, mitigation, extenuation, aggravation. And we'll begin with looking at defenses, because this is one that I've often heard various people say that, oh, defenses never come into play on an absence case. And that simply is not true. There are some circumstances. Now, admittedly, they are rare, but they do exist. So for this part of the presentation, we're going to be dealing a lot with the manual for courts martial. So if you haven't downloaded yet, you need to download it. You can find the download link. Go to centerforconscience.org, and I'm going to pull that so I can see myself where the download link is. So on the page, you see the logo, then you see the graphic, free end of year CLE, and then you see the red text. Right below that, you'll see text that says you'll also need to download a PDF copy of the 2016 yada, yada, yada. Click there, download it. It may take a few minutes if you don't have fast internet, but go ahead and download that, because, and I'd recommend saving it to your desktop or something, because we're going to be using this throughout the presentation. So I am pulling it up now on my end. As you can see, this is a 936-page document. It is a monster. And I've seen print editions of these. I've never used one because it's 936 pages. I just find it much more easier to deal with it on the computer. But a lot of people in military courts, JAG attorneys, will use a print edition. The thing about this huge document, it really consists of it's really a collection of books, not a single book. In fact, you might think of the MCM as being the Bible of the military. because the Bible has the books of the Bible, individual books. Well, the MCM has individual books or parts in the same way. So if you look at the MCM, and I'm going to start from, just give you a quick little roadmap of the MCM, because I think it really is helpful to make sense of the thing. So after you get past the pretty covering, that's the last time you see color in this document. Then we get to the table of contents, and this is maybe we're going to spend a little time here, just because navigating this document is key to dealing with military law. Of course, Part 1, Preamble. Part 2 is Rules for Court-Martial. This is often abbreviated as the RCM. So these are the procedural details of how a court-martial functions. Now, one complicating factor, the UCMJ, which is, as we talked about in the previous presentation, in the pecking order, or the hierarchy of military law, at the top is U.S. Constitution with the military-specific exceptions. Next level down are federal statutes, most notably the UCMJ, and below that are federal regulations. And so the rules for court-martial, the RCM, is at that third level, third tier. So UCMJ is above it. It trumps the RCM. But generally, the RCM is interpreting, well, it does a lot of things, but normally I can't think of any specific things where it contradicts the UCMJ, but it does elaborates. It gives more specific details. So the RCM, that whole section is Part 2 of the, and if you're looking at this in the print edition, they don't have page numbers. They all have like I-1, I-2. That's the preamble part. Then the next part is Part 2. It'll be, Roman numerals, II. So this whole section goes on for quite a while. The rules for court-martial, and then we get to, scrolling on down a bit. Now, I mentioned because the PDF version, we may get page numbers here that will. So anyway, scrolling. Actually, I don't on this. I'm using a different laptop. No, it does. So I'm at now page. Let's see here. Okay, so now we get, if you're looking at the PDF, this will be on page 19 of the PDF, or Part 3 of the Manual for Court-Martial. We now get to the MRE, Military Rules of Evidence. Military rules of evidence are very similar to the federal rules of evidence. There are some differences, but fairly similar in most aspects. But that is Part 3. Following this, we get to, and where our, okay, now for Part 4 is very important for us, and we're going to spend a little more time here in detail, this is the punitive articles. These are the articles of the Manual for Court-Martial that, well, what it does is for the Manual for Court-Martial, it takes each of the UCMJ articles, which are the specific offenses that person can commit, and then it gives a text to that statute, gives explanation, and then gives more details such as lesser included punishment, what the maximum punishment is, and what the sample specification, or how is it charged up actually, what's the verbiage. So Part 4 is really, really, really critical. And again, it's weird to me that so much of what's in Part 4 to me really should be in federal statute, much of it, but it's not. It's here. And then after Part 4, and it's not the easiest to navigate table of contents, but I wanted folks to get a feel for how cumbersome it is, but also just useful to mess with it some. Part 5 deals with the topic of non-judicial punishment. This is the Article 15 process. And again, it would be a great topic, but we'll have to save that for another day, because this is basically a procedure where someone's punished outside of a court-martial. And then finally, after that is a whole list of appendices. What I want to especially alert you to, though, is Appendices 2. That is Uniform Code of Military Justice. So, and Appendix C1 is the U.S. Constitution. Now, the reason these two, it's awkward to me these are put in the appendices because these are actually higher than the rest. But in the pecking order, really the whole of military law is found in these 936 pages. All you need to add is of course, regulations, and you need to add some case law. But most of what you'll be dealing with is right here in this one giant PDF. So, For our purposes today, though, our topic, which is mitigation, aggravation, extenuation, defenses for absence offenses, we're going to be dealing primarily with, I believe it is part 4. Well, no, that's not true. We're going to deal a little bit with a couple different parts of the MCM. Let's see here. We'll jump back over. We're going to be first we need to jump over to RCM 916, Rule for Court-Martial 916, which is going to be in part 2 of this document. So I'm now going to jump over and find that, and I'll give you the page number in just a moment. RCM 916, that's 2-115 in the document, which is, for the PDF, it's going to be a different page number. Okay, RCM 916, this is going to be on page 166, of the Manual for Court-Martial Reading. By the way, this is a good stopping point for us to give one of the codes for today's program for the second hour. So get your pen or pencil out and write down this code. The code for this block of time will be T as in Thomas, 8, N is in November, U as in umbrella. Let me read the code again. It is T as in Thomas, 8, N as in November, U as in umbrella. So this is the first of the code. Just a reminder, email these 2 codes to me for this hour after the program. If you want CLE credit, email it to gightslawyer@gmail.com. Include your name, state, and bar number in these codes. So that was the first code. I'll read it one more time. It is T as in Thomas, 8, N as in Nancy, U as in umbrella. Okay, so now let's go ahead and jump back over. In our Manual for Court-Martial, we're now on page 166, Manual for Court-Martial. The section is, this is Rule 916, Defenses. So let's read this. First part, A, in general. As used in this rule, defenses includes any special defense which, although not denying that the accused committed the objective acts constituting the offense charged, denies wholly or partially criminal responsibility for those acts. Another way to put, so a more simple way of stating this would be this way, that a defense is something that if it exists, this thing or concept, if it exists, then a criminal act, which would otherwise be a criminal act, is excused, even though if the circumstance or event didn't happen, it would be otherwise. So, looking on down, part B says burden of proof. And this is a general rule, this is very important, says, except as listed below in paragraphs 2 and 3, the prosecution shall have the burden of proving beyond a reasonable doubt that the defense did not exist. Which then, of course, brings us to those 2 exceptions, 2 and 3. So let's read those. 2, lack of mental responsibility. The accused has the burden of proving the defense of lack of mental responsibility by clear and convincing evidence. And 3, mistake of fact as to age. And the defense of mistake of fact as to age is described in Article 120B, Part D, Part 2, in a prosecution of child sexual offense, yada, yada, yada. I'm not going to read that in detail because it doesn't apply to our context here. So the basic idea here is that for any of these defenses relating to absence offenses, unless it deals with lack of mental responsibility, the prosecution has the burden to prove it doesn't exist. The prosecution can't prove that, and the issue is raised, the defense wins. On the other hand, for lack of mental responsibility, that one is different. In that case, the accused, the defendant, has the burden of proof and has to prove it by clear and convincing evidence. So, those we have to keep those in mind throughout this, the burden of proof. So now let's talk, one of those things I'm talking about is talking through each of these specific, talk through these defenses while at the same time also talking through how they relate to the elements of the offense. So now, speaking of that, let's go back and look at the elements of the offense. And the UCMJ articles, I'm not going to read them in detail here just because we just to save on time, but the UCMJ articles we're dealing with are Articles 85, 86, and 87. Now, we're going to talk about them out of order because it helps for a little bit. Article 86, I think they should have worded and put the numbers differently, but 86 is AWOL. And AWOL basically means absence without leave. Another way of putting it is absent without a lawful excuse. Now, the key here is that there's no time limit for the amount of time to be absent. You can be gone 1 hour and be AWOL. So it's not tied on time. The issue is, are you not where you're supposed to be? And did you not have a legal reason to be not where you're supposed to be? If you aren't where you're supposed to be, and you didn't have a legal reason to not be there, you are, by definition, AWOL. In other words, there's no intent element here. You simply have to show that you were absent and you had no lawful reason to be there. The elements here are super simple. For desertion, this is found in UCMJ Article 85. A way of looking at this is to say that desertion is AWOL plus one of two different intent elements. Those intent elements are either the intent to remain away forever or the intent to shirk hazardous duty. Now, the problem here is that this intent element can be met by the state of mind being met at just one single moment. In other words, let's say a soldier leaves his post without permission, but always plans on going back. But let's say a year later decides, I'm never coming back. And for an hour makes plans on how he will never come back and stay away forever. And then after an hour changes his mind and decides he will go back. And he still goes back at some point. Has he committed the act of desertion? Well, theoretically, yes, because at least at one moment, the state of mind was there, I will never go back. Now, how you prove that for the prosecution is another matter. But in this case, the intent elements at least would have been met because at least at one point, the soldier had the intent to stay away forever. The other one is shirk hazardous duty. Now, the kicker here is hazardous duty. One of the key issues in a desertion case is what constitutes hazardous duty. Is it simply being on a deployment? Or does it involve being shot at in some way? That's always an issue of controversy. But basically, desertion is AWOL plus an intent element. And also should add, it's one or the other. You don't have to prove both of them. You just need to prove one of them. Third offense here is UCMJ Article 87, which is missing movement. And the definition here says is that someone who through, this is a quote, who through neglect or design misses the movement of a ship, aircraft, or unit with which he is required in the course of duty to move. The idea here is that either someone was neglectful about it or planned to miss that movement. And that's a different kind of offense. And also I'll throw in there, not really technically an offense element, but you could argue also disobeying a lawful order may always be a factor here too, which falls under, depending on the circumstances, UCMJ Articles 90, 91, or 92. Not to spend a lot of time on that, but those are always, you could always try to argue that's a lesser included of an absence offense. So, but basically, what normally on an absence offense, you have the most basic charge is AWOL. Also, I should mention other branches call it different things. Navy, Marines, they call it UA, unauthorized absence, which is confusing to me because you often also hear the word UA used to refer to urinalysis, which is also another big part of military life. But nonetheless, Navy and Marines, they call being AWOL being UA, while the Army calls it AWOL. And I believe the Air Force calls it AWOL too, but I'm not sure. I think the Air Force does too. So anyway, these absence offenses, Article 86 AWOL is the most basic offense because it doesn't have an intent element. It's much easier to prove up for the prosecution. The more serious charges, desertion, missing movement, harder to prove up because you have, for 85, you have to show an intent element. For 87, missing movement, you have to show that there's the connection to this movement of a ship, aircraft, or unit. And you have to show that someone either was neglectful or by design missed the movement. There's some mistake that's not due to neglect, then it's not missing movement. So in practical terms, I hardly ever see missing movement charged. AWOL is very common, desertion less so. Often, though, what happens is the initial charge is for desertion, but the plea bargaining gets knocked down to AWOL if the defense attorney does their job, which we'll talk about more in this presentation. So anyway, those are the elements, and those elements are important as we think about now going back over to the issue of defenses. So let's now jump back over to the Manual for Courts Martial. And we're looking at, if you're looking at the PDF document, we are on page 166. We're looking at RCM 916. We'll scroll down a page past the burden of proof part. Starting with part C, we now have a listing of different kinds of defenses and whether they would apply here. So of these listings, of the defenses mentioned, many of these will not apply in an absence offense. So C is justification. A death, injury, or other act caused or done in the proper interference of a legal duty is justified and not unlawful. This wouldn't apply here because the proper performance of a legal duty, it would be being at your workstation where you're supposed to be. And so death, injury, or other act, I can't see where that would apply here at all. D might, obedience to orders, and the verbiage here. And again, we're on page 167 of the PDF document, but part D says, obedience to orders. It is an offense to any offense that the accused was acting pursuant to orders unless the accused knew the orders to be unlawful or a person of ordinary sense and understanding would have known the orders to be unlawful. Okay, why is this an issue? Well, the issue here is often when a soldier is not, or service member is not where he or she is supposed to be, often the issue is who gave the order they were supposed to be at a certain place, or who gave the order they didn't have to be at a certain place. How this often happens is, let's say a unit has a standing order that every morning there's morning formation at 6 a.m. You're supposed to be there at 6 a.m. no matter what. And let's say for a special occasion, some event, that the order is given by the command, you don't have to come in at 6. Come in at 8 instead. We're having a big breakfast. No morning formation. That's great. And so if you don't show up at 6 o'clock, even though there was this normal standing order to be there at 6, there's a lawful order given. You don't have to be here at 6. Now just come at 8. No issue at all because you have a lawful. And you couldn't later prosecute someone for that because the command gave this order, don't come in until 8 o'clock. Now, what happens if a service member was told through word of mouth, don't come until 8 o'clock? And what if the word of mouth was wrong? Let's say someone in the unit didn't like someone else, and so Private John Doe was an unpopular soldier. So everyone told Private John Doe, oh, don't come in until 10 a.m. The command says we don't have to, commander says we don't have to be until 10 a.m. And then Private John Doe shows up at 10 a.m. and gets yelled at, or worse. Well, the question would be, Private John Doe thought he was given an order, thought the order to show up at 6 a.m. was negated by what the command said. The question is, was it appropriate for Private John Doe to trust his peers that the order was in fact changed? Well, if we look at this defense, again, we're looking at D, obedience to orders. So in this case, the offense is he was supposed to be there at 6 a.m. and the command never actually gave the order. So then if the accused was acting pursuant to orders and he was told by others to be there at 10, the only question is, would the accused know the orders to be unlawful, or a person of ordinary sense and understanding would have known the orders to be unlawful? Meaning, was it plausible that the command would have sent out this order in this kind of way? Had the command ever done this before? If word of mouth things was a common customary practice in this unit, this might be the defendant may have a good case here. On the other hand, if the commander had said, you are to be here at 6 a.m. no matter what, the only exceptions will be sent by email or a call from your sergeant who will relay the message, or from myself as your commander. If you don't hear that, be here at 6. And so if then Private John Doe listened to his buddies and didn't show up, but also didn't get those calls, then Private John Doe, I think he would not be eligible for this defense. Now, a more extreme example I've seen is that often in basic training, a soldier may be having problems, and a young recruit, And so a first sergeant may flippantly say, "Hey, we don't want you in here. We don't want you here anymore. You should just leave, and we'll just mail you your discharge papers." And I've heard a variance of that statement told many times to me by various clients, and I've heard it also anecdotally from others. Well, the question is that should a service member assume that was a lawful order to just go home and we'll mail you the discharge papers? Well, for a young recruit in basic training, arguably, I think you could say that using this language here in Part D, a person of ordinary sense and understanding, and I think implied here is in their station, which is as a young recruit, might have understood that might be, if your drill sergeant says he's God and he rules your life, and if your drill sergeant or someone higher says to leave and not come back, you might legitimately think that you were told to not come back and that was a lawful order. On the other hand, let's say that someone was a private first class or a specialist, had been in for several years and was given that same order or supposed order. Someone who'd been in several years would know that you never leave for good without at least getting leave papers, if not a DD 214, your discharge papers in hand. No higher ranking person, it'd be kind of it would not make sense to think that. You would ask, hey, is this for real? Maybe I should go talk to my commander and find out if this really is the case or not. At least I should get something in writing saying this. And so to me, in the absence context where this comes into play is looking at, again, that issue of person of ordinary sense and understanding. And sometimes people say that, they may say that, oh, my sergeant told me to leave, and being said in a joking way. Well, someone who's in longer would know that it probably was said in a joking way. Or someone who is a recruit or maybe of impaired intelligence or something might not understand that. And so I think here the key is probing into this more in detail. Okay, continuing on the rest of the defenses. Part E is self-defense. Doesn't really apply here. We're not dealing with acts of violence when we're dealing with an absence offense. Scrolling on down, there's a lot more detail about self-defense. Also, defense of another, same thing. So those are all, again, I would argue that wouldn't apply here. Let's look at F, accident. The verbiage says, by the way, we're now on page 168 of the Manual for Court-Martial. F, accident. It says, a death, injury, or other event which occurs as the unintentional and unexpected result of doing a lawful act in a lawful manner is an accident and excusable. This falls a little bit, is connected, I think, with another defense we'll see later on, which is number I, inability. Is a defense to refusal or failure to perform a duty that the accused was, through no fault of the accused, not physically or financially able to perform the duty. So how I think these two kind of connect is, if someone, say, was driving back to post from a time of leave, they were lawfully on leave, and they got in a car accident, and they physically cannot get back. In such a case, the event would, I think either F, accident, or the other one would be I, inability would apply, because accident, of course, that a person had a duty to return. They were doing that return in a lawful manner. They got in an accident. Their absence resulted from that. Well, that would be an accident and excusable. But also in the same way, I would be inability. It is a defense to refusal or failure to perform a duty that the accused was, through no fault of the accused, not physically or financially able to perform the duty. So some examples of inability that might affect an absence case. What if someone fell desperately ill? Say they had a heart attack while on leave and hence could not get back. What if they had a mental breakdown? What if they got shot in some random act of violence? Those would be examples of inability. Another example, a very common one, is what if someone had some catastrophic situation happen where they lost all the money. They had no money to get back. Let's say their car broke down on the way back to post. In those cases where then they would be excused. The issue, though, is that if you look at I, inability, it says that the accused, through no fault of the accused, was not physically or financially able to perform the duty. So a good example of this would be, let's say that a person is on leave. They are traveling with their child. Their child is desperately ill. They spend all their money to get medicine for their child. Through no fault of their own, they had to take care of their child. Hence, they had no money to buy the plane ticket to get back home. That should probably apply. On the other hand, let's say hypothetical defendant. We'll pull out Private John Doe out of our hypothetical pile. Let's say Private John Doe decides to go when he goes on leave to go to Las Vegas, and he spends all of his money betting. Well, he has a car he should drive back to post with, but he decides instead to sell his car to get more money for gambling, and thinks, I'll make back all my money, I'll be good. Instead, he loses all of his money. Now he's not only broke, but carless. He has no money to buy a plane ticket, bus ticket, or anything else. He doesn't have a car anymore. He can't get to post. Now he's going to try to say he's unable to get back. Well, it was his fault. He is financially unable to perform the duty because he did have a car previously, but he sold it to buy for more gambling. He blew through all his money through gambling. Those are all due to his decisions. Hence, he would not be eligible for this defense. Okay, other defenses that might be an issue. Let's jump over to G, entrapment. It is a defense of the criminal design or suggestion to commit the offense originated in the government and the accused had no predisposition to commit the offense. The only scenario I can see this would apply for an absence offense is, again, the scenario we spoke about a little bit ago. What if an NCO, a sergeant, tells a lower enlisted person that they ought to go AWOL? And the sergeant's saying this just because he or she doesn't want to deal with this person anymore. Is the sergeant giving the person are they giving the suggestion? Again, the sergeant is a representative of the government. If they are planting the idea in the recruit's head and the recruit then leaves, is that a case here? Well, I think the problem here is a second part of the entrapment. And it says, and the accused had no predisposition to commit the offense, meaning that if the accused was already likely to leave, had a predisposition to leave, was already struggling in the unit, there's a high likelihood that they would have wanted to leave anyway. And so it'd be hard to argue there wasn't already a predisposition. Nonetheless, it'd be an interesting argument to try. H, coercion or duress. Let's talk about this one. This defense says, it is a defense to any offense except killing an innocent person, that the accused's participation in the offense was caused by a reasonable apprehension that the accused or another innocent person would be immediately, that's the key word, immediately killed or would immediately suffer serious bodily injury if the accused did not commit the act. The apprehension must reasonably continue through the commission of the act. If the accused had any reasonable opportunity to avoid committing the act without subjecting the accused or another innocent person to the harm threatened, this defense shall not apply. Okay, let's talk about some scenarios where this defense may and may not apply to an absence offense. Okay, first of all, let's say we're dealing with a suicidal soldier, someone who is deeply, deeply depressed, maybe dealing with post-traumatic stress disorder, traumatic brain injury, maybe other mental health issues, and that they are seriously suicidal, and they believe that if they do not leave the post right then and there, they will kill themselves. That is a scenario I've seen quite a few times. The problem is that it's really hard to prove the reasonable belief that that's immediate. The phraseology in this defense is written in this rule is that the fear that the accused or another innocent person would be immediately killed or immediately suffer bodily injury. And so the issue there is, does the person think that I might kill myself tomorrow if I stick around? Do they think I might kill myself an hour from now? If so, I'm afraid this defense probably would not help you because it's not immediate. On the other hand, if the person has a gun pointed at their head and says, I'm going to kill myself, and then think maybe I should go AWOL instead. And if I do that, maybe I won't kill myself right now. Maybe you could argue that. Maybe. It's to that level. This immediacy really throws a kink in the works here from a defense standpoint. Another scenario I've seen is what if someone, let's say a scenario I've seen not too long ago was a person who had a spouse who lived off post in an Army community. And like many Army communities, those are very rough communities. And this service member felt that the house situation was not safe. In other words, where their spouse was living was not safe. Neighbors were a problem. They thought that their spouse was in danger if they continued to live where they currently lived. and I've heard this scenario, again, multiple times in different situations. Would it be appropriate for someone to go AWOL to help their spouse to leave that situation? Again, the issue here is immediacy. I don't think there'd be any issue at all if someone went AWOL to get their spouse and take them out of an immediately harmful situation. But if it's a more generalized fear of something that might happen someday, that's not going to cut it. It has to be immediate. Also, it's going to be, the other thing is that last line says, if the accused had had any reasonable opportunity to avoid committing the act without subjecting the accused or another innocent person to the harm threatened, this defense shall not apply. So in that scenario, if the service member knew the spouse is in danger, would it be reasonable for them to instead call 911? Maybe so. And if so, that would qualify as a reasonable opportunity, and therefore that defense probably would not apply. Now, again, these are all questions of fact of how you take the specific provisions here of these rules and apply them. Different decision makers might argue differently. There's certainly some room to argue different things, but to be aware of this is what we're dealing with when dealing with these defenses. Now, we already talked about I, inability. Let's talk about J, ignorance or mistake of fact. And this is on page 169 of the PDF document. And generally, I'm going to read the generally part. The second part deals with child sex offenses. Doesn't apply here. But under J, part 1, generally. Except as otherwise provided in the subsection, it is a defense to an offense that the accused had held as a result of ignorance or mistake and incorrect belief of the true circumstances, such that if the circumstances were as the accused believed them, the accused would not be guilty of the offense. If the ignorance or mistake goes to an element requiring premeditation, specific intent, willfulness, or knowledge of a particular fact, the ignorance or mistake need only have to have existed in the mind of the accused. If the accused or mistake goes to any other element requiring only general intent or knowledge, the ignorance or mistake must have existed in the mind of the accused and must have been reasonable under all the circumstances. However, if the accused's knowledge or intent is immaterial as to an element, then ignorance or mistake is not a defense. This is a tricky one. The only thing I can think of that might apply here would be if a command gave some kind of conditional order, such as if the temperature is 20 degrees or below at formation time, you don't have to come to formation. Looked at the thermometer and it said 18 degrees, but the commander's thermometer said something different. It would have to be pretty difficult to prove this, honestly. In this, most of the other circumstances of whether the order was correct, whether that really fits better under some of the other defenses. But this particular defense, I just don't see it as much. So now moving on to K, lack of mental responsibility. Lack of mental responsibility, it says it is an affirmative defense to any offense that at the time of the commission of the acts constituting the offense, the accused as a result of a severe mental disease or defect was unable to appreciate the nature and quality or the wrongfulness of his or her acts. Mental disease or defect does not otherwise constitute a defense. And then 2, partial mental responsibility, a mental condition not amounting to a lack of mental responsibility under subsection K1 of this rule is not an affirmative defense. Now, the problem here is the level that's required here. Remember, the burden of proof is on the defense if you're trying to prove up lack of mental responsibility. So you'd have to show at the time of the offense that due to at the time of the commission of the acts constituting the offense, as a result of a severe mental disease or defect, was unable to appreciate the nature and quality or wrongfulness of his or her acts. Now, that is really, really, really tricky because you're having to prove up severe mental disease or defect and then show that it specifically made someone unable to appreciate the nature and quality or the wrongfulness of his or her acts. That is really hard to prove up. And I have yet to see someone successfully do this in an absence case. I'm not saying it does, at least it's gone to trial. And I've seen this be raised and used successfully in a pretrial context to avoid prosecution, to show that someone was not in the right mind. But when it actually gets to trial, I've never seen this be successfully raised as a defense because this burden being so high. And given also the very low bar of the lowest charge of AWOL, which is you're absent You weren't where you're supposed to be. You didn't have a legal reason to be there. There's no intent element there. So because of that, you can't really whittle away at the intent element itself. And so then you're just dealing with, does the person understand that they basically, do they know they're supposed to be at a certain place at a certain time? It'd be very hard for almost anyone in the military, unless they truly were in a very difficult state, to say, I didn't think I had to be there anymore. It's just so difficult to get there. So I'm not saying it doesn't exist, but it's very hard to prove up. Finally, so those are the defenses that could apply. Let's talk about some, also in the same section. We're now on page 170 of this document. We're dealing with a couple things that are not defenses, and these are very, very important. First one is ignorance or mistake of the law. And that says ignorance or mistake of law, including general orders or regulations, ordinarily is not a defense. In other words, if someone wasn't paying attention when the command gave an order to be at a certain place in a certain time, then that doesn't count. If they were there, they heard it, they should have known, too bad. Second one is voluntary intoxication. And this one does come up some in the military context, absence offenses. For this one, it says voluntary intoxication, whether caused by alcohol or drugs, is not a defense. However, evidence of any degree of voluntary intoxication may be introduced for the purpose of raising a reasonable doubt as to the existence of actual knowledge, specific intent, willfulness, or premeditated design to kill, if actual knowledge, specific intent, willingness, or premeditated design to kill is an element of the offense. So what that means is if a soldier gets drunk while on leave and gets so intoxicated they can't make it back to formation, that is not a defense. On the other hand, if someone was involuntary intoxication would be a different story. As well, if you are voluntarily intoxicated, you could argue that that might affect an intent element. And the intent elements, specifically on these acts and offenses we're looking at, the biggies are on desertion, the intent to remain away forever, or the intent to shirk hazardous duty. I think you could successfully argue that if the only evidence the prosecution had is that while you were in the bar, drunk, that you told someone that you planned to never go back, could that be used as a justification by itself to prove up desertion? I think it'd be hard based on this, because you could argue that there's reasonable doubt that what someone shoots off when they're drunk doesn't really reflect the true state of their mind. So you might argue that. Okay, so we've now dealt with the defenses, and unfortunately, we're really running out of time. There's just so much here on defenses. I taught on the same topic about a year ago, and I've just come across a lot more good stuff on defenses. The next part, let's move on to talking about mitigation, aggravation, extenuation. So let me find one thing real quick. Okay, where mitigation and extenuation, aggravation all come into play is in two key parts of a court martial. First, the pretrial stage. Secondly, in sentencing. At the pretrial stage, aggravation is basically anything which is related to the offense, which makes it worse, such as impact upon a unit would be an aggravating factor, such as someone's manner in which they committed a crime and doing it in a particularly disrespectful way, for instance. Anything along those lines should serve as aggravation. Extenuation, mitigation are things that don't excuse the crime, but help to put it in different context, help explain it a little bit, to maybe show the person should be punished less or not at all, even though they still are guilty of the primary offense. And so in the pretrial stage, remember we talked earlier in the first hour, we talked about how the prosecutor is really a go-between more than anything. The real decision maker is the command. The command makes a decision, do we move forward to trial or not? The command makes a decision, how far we go with this. It's all in the command's hands, which means the command is also thinking about, do I want to mess with going to trial or not? Is this someone I should just quietly throw out of the Army? Is this someone I should give another chance to? Is this someone I should throw the book at? Well, it's all going to depend on those contextual factors. And that's where aggravating factor, who's the prosecution is going to be looking for to say, no, you really need to throw the book at this person, while the defense, mitigation, extenuation are things which help to show context. Some examples, and it's a really broad definition. I'm going to look real quick. This is at RCM 1001, which is talking about in the sentencing context. It's going to discuss how these things come up. But again, remember, these issues may, I'm going to read them here because they give us definitions, but remember, these issues are the same issues that we'd be raising at the pretrial stage as well. So in RCM 1001 DC, and this is, by the way, this is on page 180 of the PDF document. It says, matters to be presented by the defense. 1. And this is talking about in the sentencing context. It says, the defense may present matters in rebuttal of any material presented by the prosecution and may present matters in extenuation and mitigation, regardless whether the defense offered evidence before findings. So basically, the defense can raise these issues even if they didn't come out previously. So, A, matters in extenuation. Matter in extenuation of an offense serve to explain the circumstances surrounding the commission of an offense, including those reasons for committing the offense which do not constitute a legal justification or excuse. And then let me read the next part, because I think these two really go hand in hand. B, matter in mitigation. Matter in mitigation of an offense is introduced to lessen the punishment to be adjudged by the court-martial or to furnish grounds for a recommendation of clemency. It includes the fact that non-judicial punishment under Article 15 has been imposed for an offense growing out of the same act or omission that constitutes the offense of which the accused has been found guilty. Now go on, it has a comma there. When reading it out loud, it's hard to make this clear. So we'll make sure it includes another clause. Comma, particular acts of good conduct or bravery and evidence of the reputation or record of the accused in the service for efficiency, fidelity, subordination, temperance, courage, or any other trait that is desirable in a service member. After that, it tells how this evidence can be brought in, and also talks about how that the defense can ask for the rules of evidence to be waived in this context, or be relaxed. I shouldn't say waived; it should just be relaxed to allow more things to come in sentencing, which is can be a nice thing for the defense. Of course, opens the door for the other side. So, as you notice here, I'm hearing extenuation mitigation. These are very loose concepts. They covered so many different things. And one of the things to remember is to be creative. There's really no limit to what you can bring in. The only thing you need to ask is, does this resonate in military culture or not? Now, I'll give you an example of a kind of extenuation and mitigation factor that doesn't always play so well. There's been cases I've known of where people who maybe were in the military reserves, who were called up involuntarily to serve active duty. And it was a great financial hardship because maybe the person was a professional of some kind, a doctor, a lawyer, something like that. And they're now being called up to the reserves where they were maybe an active duty person, an active duty enlisted soldier. And so their pay is coming from here down to here. And there's been cases where someone doesn't show up, goes AWOL, doesn't show up for what they're supposed to show up for. Well, the problem is if you try arguing this in a court-martial, that the reason is that this pay drop, the problem is the people hearing this also feel like they're not being paid enough. And many of them may be defensive of this issue and may not feel a lot of sympathy towards someone who didn't show up because of a pay drop. And so that's a touchy one to bring up. Yes, you could argue it, but you'd have to do it carefully. Another example, though, of a kind of mitigating or extenuating factor that may be very persuasive to many people in the military is this. Let's say the soldier goes on a deployment. While they are gone, they have a spouse back home who they're madly in love with. They are committed to, they stay faithful to them on the deployment, but they get word that their spouse is having an affair with and so they ask for leave. They are granted the leave time. They go back home to try to win their spouse over. They can't win her over. They keep trying. They keep trying so long that they miss their flight back to the deployment. Now they are technically AWOL. Is it a defense to AWOL that you're upset because your spouse is having an affair? No, that was not a defense we read earlier. No one's in imminent harm of death or any of that stuff. Just there's no defense. But is it extenuation mitigation? Yes. It is a circumstance, quoting here for matters of extenuation, it explains the circumstances surrounding the commission of an offense, including those reasons for committing the offense which do not constitute a legal justification or excuse. This is a scenario that many service members will be familiar with, spousal infidelity while on deployment. They may be very sympathetic about it. They may have friends that went through this. They may themselves have gone through this. Because of that, that is a mitigating, extenuating circumstance that many people on a jury panel and many judges would find very sympathetic. The key is you have to find ways to tug people's heartstrings. This is not an objective criteria here. These are very subjective when you're dealing with mitigation extenuation. Another thing to remember is that fundamentally the military is a political institution, meaning they desire to have good press, to maintain good feelings, to maintain good PR, which means in practical terms that mitigating extenuating factors that are embarrassing to them are things that they may not want to come out at trial. Those are the kind of things that are very useful in negotiating the pretrial context. For instance, if a service member went AWOL because they had untreated PTSD or some other untreated physical or mental issue, again, is not a defense unless they were imminently about to kill themselves. Otherwise, not a defense. But is it extenuation? Yes. And is it extenuating evidence that would be embarrassing to the military? Yes. Hence, that is very good stuff to use at the pretrial context. So my advice when dealing with mitigating, extenuating, and aggravating circumstances is to think creatively. One, look for that aggravating stuff and try to find a way to explain it away, to find a way to combat it, to push it aside, to explain it so that it doesn't have the impact it might otherwise. One of the biggies, and I've had fun with this one before, is I've had cases where the prosecution wanted to argue that this person is a terrible, terrible human being and that spent all this time building this case how terrible they were. And then when they get to sentencing, they want to say that, and look what harm it did to the unit, the person left. Well, the easy rebuttal of that is that this person is so terrible. Maybe this guy leaving did the unit a favor. Well, how should he be punished? The unit wasn't impacted. And you'd bring, and then from our side, we bring up, we would cross-examine witnesses to say, hey, was the unit really impacted negatively by this guy being gone? And after they'd already spent so much time saying what a trouble the person was, it's kind of hard then to argue the unit was impacted negatively by their absence. That's the kind of case, you can take, what would be an aggravating factor, someone did not have good job performance when they were there, and turn it into mitigation extenuation. It's kind of fun. But basically, we're looking for anything that can help turn things around. And remember that mitigation extenuation does not have to fit into those very narrow, defined categories as defenses. And so you're really looking at what can persuade, number one, first and foremost, the command, the person who's a decision maker here, to try to avoid things going to a court-martial in the first place. And hopefully persuade not just to avoid a court-martial, but to get good treatment after this. For a client who wants to stay in, maybe it might mean being transferred to a unit that's a better fit for the person. For someone who wants to get out, to get a good discharge, not a bad discharge. Or to just simply avoid a court-martial, even if it means it being kicked out. These extenuating mitigating factors are things that can be used to turn things around. The key is documentation, and documentation comes in many ways. Paper records, of course, are ideal. If you have anything in the military records themselves that back your client's story, that back what you're trying to say, mitigating, extenuating evidence-wise, great. Pictorial evidence of any kind is always helpful. If a mitigating extenuating factor is a sick child, then we need a picture of the sick child. If it's family issues, we need pictures of the family. Ideally, we need to have family members ready to testify, people willing to give written statements. All of those things can be game changers, can be things that can put things in a better light. It can be written statements from the client. It could be at the pretrial stage. I'm a little hesitant about having the client put anything in writing themselves. There are some ways of doing that and avoid it being entered into evidence later, but it's tricky. At the post-trial stage, or not post-conviction, but in the sentencing hearing, it's different because the defendants in military get to make what's called an unsworn statement, which they cannot be cross-examined about. It can be in verbally or done in writing. They can say whatever they want. This is a time to get in more evidence, more explanation of extenuating, mitigating factors. And again, always be creative. One thing I'd always say when it comes to this is that everybody, I don't think there's ever a case that there isn't something that can be said positive for extenuating and mitigating circumstances. If nothing else, you can go with the blanket stuff that's in part on, we're page 180 of the PDF on part, on CB, the part about matters of mitigation. Towards the end, it says, includes particular acts of good conduct or bravery or evidence of the record or reputation or record of the accused in the service for efficiency, fidelity, subordination, temperance, courage, or any other trait that is desirable in a service member. Well, surely you can always find some evidence of efficiency. Surely there are times that the service member, even if they had bad conduct sometimes, may still have had traits that were desirable in a service member. So it really can be anything. The key is to never give up. It's too easy to take the lazy way out, in my opinion. The best way to get a good outcome is to find ways to prove this extenuating, mitigating stuff, get it out there. Again, always try for it at the pretrial stage. Do what you can with it. But then if it gets to sentencing, use it there. And then if it doesn't work at sentencing, this same evidence, where it can be used, it can be used post-trial in clemency. This same evidence, including letters, statements, all of that can be useful. There's a lot of ways of proving this stuff up. So, well, we are about now time at 3 minutes left. So if anyone has any questions, you're welcome to ask them on the group chat here. I will mention that we will have this as an on-demand thing later on. I'll have maybe the next day or two set up so that if you know someone who would have loved to have seen this webcast but couldn't see it live, please encourage them. I'll probably give it a day or two. I'll have this as a recorded thing. In states that allow on-demand CLE credit, my understanding is that they'll be able to go through the process to get CLE credit for watching it the same way as you did here today. But let folks know about that. Also, while we're at it, since we're at the end of the broadcast, I want to mention the second and final code that you'll need to claim credit. So get your pen or pencil ready. And the code is O as in Oscar, 7. R is in Romeo, Y is in Yankee. So please write that code down. Second and final code is O as in Oscar, 7, R is in Romeo, Y is in Yankee. And again, you can send to get the credit, you'll need to send your email to girightslawyer@gmail.com with your name, state, and bar number, and then give me the codes. Again, one more time, repeating the last code. It is O as in Oscar, 7, R as in Romeo, Y as in Yankee. So send those to me. And then if you're from Oklahoma, we have the application pending at the Bar Association. As soon as that's approved, we will send in showing that you completed the credit before the end of the year, so you'll get credit for that. If you're not from Oklahoma, we will send you your certificate and a uniform application for accreditation of CLE credit that you can send to your state bar association. So you'll have that. Also, I want to mention, if you have ideas for future webcasts like this, the organization is working with today, the National Lawyers, Military Law Task Force, the National Lawyers Guild, as well as CCA, the Center for Conscience and Action. We would love to do more CLE programming. So if there's a topic in military law issues you would like to hear CLE on, we'd be very interested in doing this again. And if you know someone who'd be a great presenter, if you'd like to hear someone else besides me talk, we'd love to hear from you as well. So send me those thoughts via email at girightslawyer@gmail.com. Lastly, I'll mention there'll be some more materials we'll be sending along with what's already been posted. So when you send in your emails, I'll send you more materials as well that's coming later today. But we'll also post those on the website at centeroverconscience.org/CLE. And I think we are about up. So thank you so much for tuning in. If you have any other questions, shoot me an email. And that's all for now.